Ladies and gentlemen, I welcome all to my channel. Today, let us discuss about latest judgment pronounced by Supreme Court with reference to the GST Act, and in this judgment, in this case, some of section 69 and 70 of the GST Act empowering the GST authorities to arrest the persons for GST violation and to issue summons are challenged before the Supreme Court. In the judgment, the Chief Justice of India, Justice Sanjeev Khanna, with two other judges, delivered a judgment in the last week of February in a case which is called have the case title Raziaq Agarwal versus Union of India in writ petition criminal number 336/2018, which is reported as a judgment in a citation 2025 Live Law Supreme Court 255. So in this case, the section 69 and 70 of the GST Act was challenged as unconstitutional and ultra virus of the Constitution. Section 69 of the Act empowers the GST, the Commissioner to issue, gives the power to arrest. So by an order, the Commissioner can authorize any officer of the Central Tax to arrest any person. So the Commissioner can pass an order to arrest any person under Section 69. Under Section 70, the officer can issue summons to give evidence on to produce documents. So these are the two sections which is challenged before the Supreme Court in the opposite case. So the main issue raised in the main grounds raised in this case is that under Article 246A of the Constitution, the Parliament and the state legislature has the authority to pass to enact GST laws. So in this article, the article does not explicitly authorize this Parliament or the state legislature to make criminal to make the violation of the GST as criminal offences. So the Article 246 simply empowers the Parliament and legislature to enact GST laws, but it did not specifically empowers to pass any to make the GST violation as a criminal offence. Further, it was contended that entry 93 list 1 to the 7th schedule empowers the Parliament to make criminal provisions only for the matters listed in list 1. So for any other matter, criminal laws cannot be enacted, like what the matter was argued before the Supreme Court. So but the Supreme Court did not accept this argument. So the Supreme Court said the Article 246 is a special provision defining the source of law and the field of legislation of the Parliament. And the court also said the Parliament under 246A of the Constitution has the power to make laws regarding GST and as a necessary corollary enact provisions against tax evasion. Article 246 of the Constitution is a comprehensive provision and the doctrine of fifth and substance applies. The impugned provision lay down the power to summon and arrest, powers necessary for effective levy and collection of the GST. So like what the Supreme Court observed, and the challenge made as against this section was nullified and rejected by the Supreme Court. So in addition to that, there was a complaint that the GST authorities are repeatedly threatening and using this provision as a weapon to pressurize the parties to pay tax, like what it was reported before the Supreme Court. But as far as these activities are concerned, the Supreme Court specifically clarified that such type of criminal threat, such type of pressurize are totally illegal, like what the Supreme Court observed. So the Supreme Court, in its in giving various findings, they reported that the GST officials coerce the allegation that the GST officials coerce the assessee to pay tax with the threat of arrest. The Supreme Court declared it as impermissible. The Supreme Court said it cannot be permitted. Then another important thing is that before passing of this judgment, so once the arrest is made, then the party shall be entitled to apply bail. That person alone was available to the assessees. They cannot apply for anticipatory bail before the judgment. But in the judgment, the Supreme Court specifically empowered the parties to apply anticipatory bail. So after this judgment, if any person faces any threats from the GST authorities, they can apply anticipatory bail and they can very well safely get a bail before making any such arrest. So this is one of the gift given to the citizens of India as against the threats of the GST authorities. So furthermore, the court has clarified under what circumstances such type of arrest order can be passed by the commissioner. As far as in giving an interpretation, delivering the judgment, the court has clarified the powers of the police and with that of the powers of the GST authorities. As far as the powers of the police is concerned, when the police got a suspicion that a particular person has committed a crime, then he can arrest the person. So this is the power of a police. But as far as this Revenue Act is concerned, mere suspicion is not enough. The judge has stated that the officer who passed this order for arrest should believe to satisfy that such person has committed the offence. So this is one of the criteria, condition, precedent to make any such order. So just because the commissioner get a suspicion that a particular person has committed an offence, he cannot pass the arrest order. So he must have a reason to believe that such person has committed an offence, and he should also record the reasons, and he should also specify the materials for such suspicion, for taking such findings and for his belief. So these are all the conditions required. The Supreme Court stipulated that these conditions should be satisfied before making an order of arrest by the commissioner. Again, in the judgment, it is very clearly explained that only the commissioner, even as per the Section 69 of the GST Act, only the commissioner has the power to issue order. So all the subordinate cannot simply issue arrest order. So by the arrest order can be issued only by the commissioner, that to do compliance of all these conditions stated in Section 69 and 132. As far as the Section 169 is concerned, it has empowered the commissioner to make an order for an arrest in the circumstances the commissioner has a reason to believe that a person has committed any offences specified in Class A or Class B or Class C or Class D of subsection 1 of Section 132. So as only for the offences which is stipulated under Section 1 Class A, B, C, D of Section 1 of 132 alone, the commissioner can pass arrest order. So now you may be asking what are the things specified in 36 A, B, C, D of section 132. So as far as section 169 is concerned, it gives the power to the commissioner to pass an arrest order. As far as section 70 is concerned, it empowers the officer, the proper officer under this act has to issue summons to any person whose utterance is necessary either to give evidence or to produce documents. So as far as the power to issue summons is given to the officers of the GST authorities, and as far as the power to arrest is given only to the commissioner. That too for the offences stipulated under section 132 subclass 1, subclass A, B, C, D. Now you may be asking what are all the things listed in section 132 A, B, C, D. So I read the sections. Whoever commits or causes to commit, or I read the section 132 of the GST Act. 132 punishment for certain offences. Subclass 1. Whoever commits or causes to commit or retain the benefits arising out of any of the following offences, namely A. Supplies any goods or services or both without issue of any invoices in violation of the provision of the Act, or rules made thereunder with the intention to evade tax. So class A is supplying of goods or rendering of services without any bills to evade tax. Then B, what is B? Issues any invoice or bill without supply of goods or services, both in violation of provision of the Act, thereunder leading to wrongful availment or utilization of input tax credit. So B is that without proper supply of material or without doing any service, issuing false bills for the purpose of getting wrongful availment or utilization of input tax credit. Then the C, puts tax credit using invoice or bills referred to class B, or fraudulently avails input tax credit without any invoice or bill. So under C, without any invoice or without any without any invoice or bill, fraudulently availing input tax credit. So that was clarified as an offence. Then the D is the class where it says collects any tax amount as tax but fails to pay the same to the government beyond the period of 3 months. So collecting a tax, GST tax, and failing to pay the same to the government authorities for more than 3 months is also classified. So these are the 4 things which is classified as an offence for which the commissioner has the power to issue arrest. So not only these, so as far as the Act is concerned, only for these 4 things commissioner has the power to arrest. Commissioner has the power to issue arrest order. As per again in class, again after in the same subclass 1, it has been specifically mentioned that this class A to L class A, the several circumstances A, B, C, like that. It has mentioned 7. It has been mentioned up to A, B, C to L. Events shall be punishable where the amount of tax evaded or the amount of input tax credit wrongly availed or utilized or the amount of refund wrongly taken exceeds 500 rupees, which with imprisonment which for a time which shall be meted to 5 years. So here for 3 A, B, C, D 4 classes, it was specified that when such type of tax evasion exceeds 500 lakhs rupees, it shall be punishable with 5 years of imprisonment. The similar tax evasion, if the similar tax evasion exceeds 200 lakhs rupees but does not exceed 500 lakhs rupees, for which the punishment shall be 3 years. The same for the same tax evasion when it exceeds 100 lakhs rupees but does not exceed 200 lakhs rupees, then the punishment shall be 1 year. In other cases, in classes for the class F alone, so for the AB, for class 1, class 2, class 3, it has been specifically clarified that only for the tax evasion exceeding 500 lakhs rupees, 5 years imprisonment. When the tax evasion is more than 200 lakhs rupees but less than 500 lakhs rupees, 3 years imprisonment. When it exceeds 100 lakhs rupees and but it is less than 200 lakhs rupees, the punishment shall be 1 year. But if the tax evasion is less than 100 rupees, the Act did not say anything about that. So it means that if the tax evasion is less than 100 lakhs rupees, then the commissioner cannot invoke section 69 to make any arrest warrant. That is the meaning which the Act says. Again, with respect to in class 4, it says when in cases where he commits or abets the commission of offence specified in class F, he shall be punishable with imprisonment for a time which may extend to 6 months. So for the violation of the class F, the punishment is 6 months. So now you may be asking what is mentioned in class F. In class F, it has mentioned falsification or substitution of financial records and the production of fact documents or documents or furnishes false information with the intention to evade tax. So whenever whoever makes falsified documents, falsified records or fake accounts, that is also punishable under class F. For these things, the amount of the tax evasion amount was not mentioned in this Act. So these are all the 4 things for finance for the first A, B, C, D classes. If the amount exceed 100 lakhs rupees, it is categorized as a offence for which the commissioner has the authority to issue arrest order. If the amount does not exceed that 100 lakhs rupees for the class for the things mentioned in the class A, B, C, D of section 1 of subsection 1 of section 132, then nothing was mentioned of nothing was categorized in offence, so it will not amount to an offence. As far as falsification of account is concerned, false fact for the production of fact document is concerned, then it can be treated as an offence irrespective of the value. So these are all the explanation given by the specifically dealt with in the Supreme Court judgment. In delivering the judgment, the Supreme Court has held that the provisions of rights of arrested person applicable to GST and Customs Act are have to be all the principle laid down in the Criminal Procedure Code has to be followed. As far as the allegation mentioned, allegation complaint, namely the GST officials are coercing the assessees to pay tax with the threat of arrest, the Supreme Court categorized this as illegal and it is not permissible. Regarding anticipatory bail, the Supreme Court clarified that the parties are entitled to make up an application for anticipatory bail. And as far as the arrest is concerned, when the GST officer is making an arrest order, he has to preliminarily satisfy that the offence has been committed. He has a belief. He believed that the offence which is specified under section 69, which is clearly mentioned in section 132 class 1 A, B, C, D, has been committed, and he has a reason for that, and he has to specify the reasons, and he should also specify the materials in support of his decision. So these are all things it has to be complied with when the GST authority and the commissioner is passing an arrest order. So these are all the things specified, clarified, guidelined in this judgment. I hope this judgment is useful to useful to the all persons who are facing threat in the in the GST issues. So I hope you'll. I hope you'll. I believe that this video will be useful to you regarding all your queries regarding legal aspect. If you you can watch my videos. I have two channels, Raziaq Sattam Marivom and Raziaq Tamil Latube. In both the channels, you can see various videos covering various topics through which you can clarify all your legal doubts, and also you can enrich your knowledge. In addition to that, if you have any specific queries, you can also contact me. This number, if time permits, I can give you required consultation depending upon my time and availability. I will come again with another topic. Until then, goodbye. Raziaq Ali. Before closing that, whoever do not subscribe my channel may subscribe my channel, and you can also click the notification icon. That will help you to notify all my videos whenever I post a new videos. Thank you. Raziaq Ali.